this is a generic order. It doesn't say, as the court referenced earlier, place this individual in the town of Wheatland in Kenosha County. It basically is a blessing of or an approval of a placement, which DHS is charged with basically vetting or investigating. So what we have before this court today, looking at the work that DHS did or did not do, and there's no affidavits in opposition to this, but shown within those affidavits is the fact that DHS, at no time did they basically seek and obtain approval or input from the Kenosha County Sheriff's Department. They sought input, and what they got from the Kenosha County Sheriff's Department via the Smith affidavit and via Sheriff Betts' affidavit is confirmation that there is in fact a child adjacent to this property. Now, you're gonna hear some argument, form over substance, we just talked about it a little bit in regards to the ordinance, but you're gonna hear some argument about why that really doesn't matter, or why DHS determined that it didn't matter and they could still move forward with placement. You're also going to hear, and you've seen within the affidavits, that the county's victim witness department was not consulted. There's no dispute as we sit here today on that, at a very preliminary stage in this hearing, they weren't consulted. 980 requires them to be consulted. We look at just the restrictions on placement under 980, which should be 1,500 feet from county maintained bike trail in this instance, which is nearly adjacent to the property. That's shown within the Santelli affidavit. There's a litany of evidence in argument form, if you will, or affidavit form before this court that DHS did nothing it was required to do under 980 to actually investigate, vet, and approve this property. They want to stand behind, the state wants to stand behind 980 and preempt local ordinance under 980-135 saying local ordinance cannot prohibit placement under 980. I'd put before this court, this is not a placement under 980 where the state of Wisconsin has obliterated it or disregarded it. So they can't stand behind that protection today and ask you basically to disregard everything they haven't done essentially. If we talk about jurisdictional issues, you're gonna hear about that. We're talking about local harm here. We're talking about the town of Wheatland, Kenosha County. This is another circuit court of parallel jurisdiction which signed an order, which I don't see anywhere on the order, maybe there's another order out there. I don't see anywhere on this order signed by Judge Torhorst where it says, place Mr. Michael McGee in Kenosha County, in the town of Wheatland. So I think the jurisdictional argument at this stage does not hold water. I understand on the face you have competing circuit court judges, but we don't even know what Judge Torhorst ordered. I agree with the court. My understanding and its argument is that he approved placement, and he was told by DHS, this place is fine. We can see based on the affidavits before this court that DHS did not do what it's charged to do. At least the prima facie case is made to that effect, and I don't believe there's any way could move forward with this placement right now. In fact, I believe it should be enjoined. I believe Ladoga, I think I have it as Lagoda, should be enjoined as well until there's some determination made, either that DHS followed 980, some determination made that the order in fact is to place Mr. McGee in Kenosha County, Wisconsin, and not just outside of his home or offending county. Until those findings are made and until there's some record there, and I think the burden falls on the defendant, and the burden here should fall on DHS in the state of Wisconsin to make a record before a court as to those findings. Until that happens, the state of Wisconsin can't stand behind 980 and say, well, you're preempted, town of Wheatland, too bad. So I believe what's before this court right now is sufficient for the court to enjoin this particular placement subject to findings made, and I'm not asking you to be a court of appeals, but there's gotta be something more.